Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome, good evening. This is Ask a Lawyer here on CP24. So good to have you along for the next half hour. Tuck in, you're going to learn a lot of stuff. Host John Scholes right here, joining you in just a moment. Lior Samfiru, employment lawyer from EmploymentLawyer.ca. You can always reach out, encouraged to do so. As a matter of fact, when you're not watching this program, 1-888-861-4555. That is the number. Email is ask@employmentlawyer.ca. We'll give you some more contact information throughout the show. We're going to get to a true or false a little later on in the show. That's always good. Historically, Lior would ask me the questions and I would get them all wrong. So I've kind of turned the tables for the last 10 years. So that doesn't happen anymore. So you're going to get the proper information in just a few minutes. So that's good. But you always start off, Lior, with the week that was something that you've been working on, pal. What would that be this week?
I promise not to put you on the hot seat this week. I'll go on the hot seat myself. But it's great to be here. And it's great to talk about employment law and to hopefully try to demystify this topic. We all have rights. We all have jobs. So those rights and those jobs often connect, and we need to understand what to do if you're facing a workplace problem, if your boss gave you an ultimatum, if today was your last day and you lost your job, what does it mean? How can it happen? What should you do about it? On the show, we talk about these things and many, many other things. So by watching us, you'll be better informed, better educated with respect to your workplace rights, and that's a good thing for everyone. And of course, I can tell you a lot of information on the show. What I can't do is listen to you. So for me to listen to you and to tell you about your specific situation, you can reach out to me afterwards. We'll give you that contact information throughout the show, so don't hesitate to do that. But as I always do, I want to start off with the situation that came across my desk. I spoke with a lady that for 12 years had worked for the same small retailer. Well, about 3 years ago, that business was sold to a new owner, and she continued working with the buyer. No changes. Her job stayed the same, or work location, pay, everything stayed the same. Fast forward 3 years later to now, the company is shutting down, and they let her go. Company says, well, you've been with us for 3 years, so we're going to give you 3-week severance and off you go. Well, for some people, that may think, well, it's kind of a week per year. Is that okay? False, wrong, not even close to being okay. Well, let's start with the fact that 3 years ago, when the business was sold, the new company inherited her service. That's what happens with the sale of a business. If you continue working with the buyer inherits your service, meaning if they ever let you go, they have to pay you severance based on your total years of service. So she is now a 15-year employee, not a 3-year employee, 15-year employee. So she's owed right around 18 months of severance. Not 3 weeks, that's what she was offered, 18 months. That's extremely important to remember, whether you work for a small company or a huge company. If that business is sold and you continue working, that seniority follows you unless you sign something, an agreement that gives it up. So you want to be very careful not to give up that seniority, not to give up that future severance. And if you're not sure if your business is being sold, what to do, what to say, who to say it to, give me a call.
I want to make mention of a website quickly, EmploymentLawyer.ca, EmploymentLawyer.ca. Among other things, you can also go to the Knowledge Center, drop-down menu Media. There you'll find a host of radio stations pretty much across the country that carry our weekly radio show, including News Talk 1010, Sundays at 1 p.m. You'll catch Lior and myself or another lawyer from the firm. Opportunity for you to call into the show, ask some questions. We pick some of the good calls from the show during the radio show, and we play them back here. We talk about them and open up about that. Let's do our first phone call right now.
If I'm with a company for a couple of years, right, and they've come to employee and said, listen, your business is going to be transferred to another company. You're not going to lose any vacation and any years of service. But if you choose to not go over to the company, you're only going to get the minimum 2 weeks per year of severance pay. Should I just go into this new company without taking the package or take the package that they're going to offer?
Well, here's the thing, John. This is very important. If you're being told you're going to lose your job, regardless of the reason, you get your full severance. A company doesn't get to limit your severance. So the first thing is getting an understanding of what your full termination entitlements are. Now, the one thing I want you also to remember is that the company doesn't get just to say you're going to go to a different company. You have a say in that. This is not the days of slave labor when the company can just say you work for this, you work for that. No. If you started with one company, they can't just decide to send you somewhere else. They don't have the right, they don't have the ability to do that. So this person, if they say no and they lose their job, they get their full severance. And of course, we have PocketEmploymentLawyer.ca if you want to know how much you're owed. Company doesn't get to make that call.
Employment law, true or false? The pressure is on. We're going to get to that after a short break. Lior's stepping up for that one. You can play along as well and see how many you know. In the meantime, I'll give you some contact information as we get into a short break. The phone number, each and every time, 1-888-861-4555 is how you reach out. Ask at EmploymentLawyer.ca. We'll continue with lots more of Ask a Lawyer here on CP24. Don't go anywhere.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. This is CP24. John Scholes, Lior Samfiru from EmploymentLawyer.ca, reaching out anytime at all. 1-888-861-4555, the phone number, right? Email is ask at EmploymentLawyer.ca. All right, let's get into the main topic. I love when this one comes up in the rotation once in a while. It's the employment law, true or false. I always say Lior's in the hot seat, but then it just occurred to me you might have written these questions, which makes no sense, but that's okay. At least it's not me answering them. So here we go. We'll get to 4 or 5 of these, Lior. Number 1, employment law, true or false. If you are disabled and can't work, your employer can hire somebody to replace you.
So yeah, I am cheating because I did write these, so I kind of know the answer. But this one actually may surprise people in all seriousness, John, because that statement is actually true. Your employer can actually hire a replacement if you're off on a disability leave. And the reason for that is an employer is allowed to run its business, and if the position you're in has to be filled while you're off because someone needs to do it, then your employer is allowed to bring someone to do it. Now, that does not mean that just because you hire there's a replacement doing your job that you're let go. That doesn't mean you don't have a job. All that means is when you're ready to come back to work, whether it's after a month or after a year, your employer has to make all efforts to bring you back. If your position exists, they have to give it to you. If the position doesn't exist or it's not available, they have to try to find something else for you. And if they've tried and if they can't, that there's nothing there, then and only then can they consider letting you go with your full severance. But the fact that you've been replaced in the interim doesn't mean that your employer's done something wrong. The key point in time is the one when you're ready to come back to work.
Okay, employment law, true or false. Number 2, Lior, is this: it's okay for your employer to demote you as long as your pay is not reduced. They don't touch the money.
Well, this one is absolutely false. Yep. A demotion is a big deal. Even if your pay has not changed, a demotion means your status within the workplace has been impacted, your future career and career goals may be impacted. It's not something your employer is allowed to do. A demotion, if it's a true demotion where you're in a less senior position, can result in what we call a constructive dismissal, even if the pay is the same. So if your employer does demote you, you may have the ability to treat that as a termination, to consider it to be a termination and get your full severance at that point. So no, it's not true that you can be demoted if your pay is the same. That's absolutely false.
Okay, number 3, true or false. It is you are better off not having signed an employment agreement with your employer.
That could not be more true. You are far better off never having signed that employment agreement. Taking a job on a handshake, taking a job over email, taking a job over something in the back of a napkin. That is far better than signing a 10-page employment agreement. What that employment agreement would do is often take away rights that you would otherwise have and either eliminate them or give them to the employer. By not signing an employment agreement, all that means is that you have all the rights that the law provides. You have the full protection of the law. So for an employee, far better not to have signed an employment agreement. So certainly don't go out there asking your employer for a written agreement. You don't want it.
We are working our way through employment law true or false this week. Number 4 is this one, Lior. If you're on a performance improvement plan and your performance doesn't improve, you can be let go for cause.
False, false, false. Not true at all. It is extremely difficult, very difficult, to terminate an employee for cause with no severance. And the fact that your performance may have been lacking, even if you were put on a performance improvement plan, does not mean that it rises to the level of a termination for cause. The failure to pass a performance improvement plan does not mean that you can be let go for cause. The company can still maybe choose to let you go, but they're going to have to pay you your full severance, and that could be as much as 2 years' pay. So remember, bad performance does not mean a termination for cause. Also, doing something wrong, making a mistake, getting into an argument does not mean termination for cause. And most of the time, if you are let go, even if you've done something wrong, full severance is still owed.
Okay, Lior, one more of these. True or false? When you are let go, your severance package must factor in your bonus.
That is 100% true, completely true. And the reason we mention it today is because oftentimes, too often, an employer conveniently forgets to include the bonus. Remember, your bonus, your commission, your car allowance, your benefits all have to be included as part of your severance, because it includes all components of your compensation, not just your salary. And oftentimes employers choose not to do that, which is wrong. That would be a wrongful dismissal. So if you want to know if something needs to be included, you ask yourself, would I have received it had I continued working? If the answer is yes, I would have received that bonus, I would have received that car allowance, I would have had those benefits, then guess what? It has to be included as part of your severance.
As I mentioned earlier on the show, guys, EmploymentLawyer.ca, that's the website you go to find a radio station in a market that you're in, and you can catch our weekly show, including right here in Toronto, a sister station to CP24 News Talk 1010. That happens Sundays at 1 p.m. Phone call number 2 from our radio show, Lior. Let's talk about it's coming up right now.
I was on stress leave from my job, and they asked me to supply a note by a certain date from a doctor's note to extend my medical leave. I called to try and book an appointment with my doctor, but I wasn't able to get in the day after their deadline was. They served me the day of my doctor appointment and fired me because they said I abandoned my position. I was there for 3 years. I was in inventory management. I'm 50.
Nonsense. Can't do that. You can't just arbitrarily impose a deadline to get a doctor's note and then fire someone or consider them to have abandoned their job, which is more ridiculous because they can't do that. It takes time to get a doctor's note. It takes time to see a doctor. That doctor may take some time after that consultation to provide the note. Nonsense. So all you'd have to do is tell your employer in that situation, I'm working on it, I'll get it to you as soon as possible. By this employer jumping the gun and considering this employee to have abandoned their job, that's a human rights violation. That's illegal. So remember, as a lesson here, if your employer wants you to give a doctor's note, they're allowed to, but they need to give you reasonable time. Tell them that you're working on it. If they do anything to you, call me. Now, beyond just, of course, human rights issues here, this person is owed severance because they didn't abandon their job. So, of course, the next question, of course, is how much severance is this person owed? Well, we're going to do what we always do on the show. We're going to use our severance calculator tool, which you, of course, can find at pocketemploymentlawyer.ca. It's free and anonymous. Let's see how much severance this person gets. So inventory manager, been there for 3 years, was not provided any severance because her employer says she abandoned her job, which, of course, she has not. Well, you see she's owed as much as 6 months severance. 6 months severance is what she's owed. It's easy to find out for yourself. Just go to pocketemploymentlawyer.ca. And remember, you cannot be let go because you're sick.
We have one more phone call standing by, but I got to get into a quick break before we do that. We'll do it on the other side, so stick with us. In the meantime, here's that contact information again for you. Anytime, 1-888-861-4555. Email ask@employmentlawyer.ca. This is Ask a Lawyer here on CP24. Stick around. We are coming right back with more.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer here on CP24. As I've mentioned a couple times already, EmploymentLawyer.ca, the website, that's where you're going to find links to our long-running radio show and the phone call anytime as well, 1-855-861-4555. Ask at EmploymentLawyer.ca. Love our phone calls. We do it across the country pretty much, including News Talk 1010. That is Sundays at 1 p.m. You'll catch our show, a chance to call in, talk to Lior and myself. Let's get to phone call number 3 and see what happens there.
My husband just got let go on Thursday. He served with this company for 12 years. He's a sole breadwinner for a family, so it's a bit of a shock to us. He was called in on Friday to accept the settlement, but luckily he didn't go in because we had something come up. So we have until Monday now to see what they offer. And he's $75K a year in his position. He is 38, telecommunications, sales.
So this situation that he's in, obviously he's feeling stress, anxiety, he's the sole breadwinner. In a way, a company may count on that when they give these severance offers. They give you the severance deadline. You have to sign this by Monday, by Friday, because they know you're not necessarily in your right mind. You're under a lot of stress and anxiety, and maybe you'll sign it without even thinking this through. Well, the reason why we're here telling you is that you can't do that. In most cases, 90% of cases, whatever the company offers you is a lot less than what you're actually owed. So you need to find out and understand what you're owed before you sign it. One of the ways to do that, we mentioned it before, is the severance calculator. It's free. It's anonymous. It takes seconds. So let's take that and apply it in this situation. You can find it, of course, at pocketemploymentlawyer.ca. So how much is this person owed? How much severance? Sales role, been there for 12 years, 38 years of age. Well, you can see he's owed 14 to 16 months of severance. So when he goes in on Monday to take his offer, he'll know it needs to be between 14 to 16 months. If it's not that, he knows to call me. He knows to reach out because he's owed more. Same with you at home. Check out pocketemploymentlawyer.ca.
Let's slide into a quick question we got from email recently. Lior goes like this, says, my boss just laid me off after 6 years. When I asked for my 2 weeks pay, he laughed and said the construction workers don't get anything when they're fired. Is that true?
Well, both employee and employer are wrong here.
Yep.
Well, the employer is wrong because, yes, construction employees do get severance. Absolutely. In fact, they get severance calculated in the same way as every other employee. The employee is wrong because he thinks he's only owed 2 weeks. Absolutely not. It's a lot more than that. So it's not 2 weeks. It's not a week per year of service. I've been hearing for years from construction employees that are shocked to find out that they're owed severance. So if you're in construction, yes, you get severance. That could be as much as 2 years' pay. And after 6 years, you're probably looking at 8 or 9 months severance. You can, of course, also use the severance calculator at pocketemploymentlawyer.ca. It's a myth. It's a misconception. Yeah, you get severance.
We have time for another question. We're going to do that on the other side of the break, so stick around for that. I'll go into the break with some more contact information. That phone call, always encouraged to make it, right? 1-888-861-4555. Ask at EmploymentLawyer.ca is how you reach out through email. And we'll continue with more of Ask a Lawyer. Stand by. Coming right back.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back. Ask a Lawyer here on CP24. A couple minutes to go, so let's get to it. Lior does, among everything else he does in his job, he does a lot of live streaming on YouTube and Facebook. You want to reach out and join that conversation at stlawyers.ca is how you do that. Let's get to that question, Lior, before we wrap up for the show. It says, I got a job in 2021 in a specialized role. It was a hybrid work arrangement with 2 days a week in the office. I've just been told that I have to go in every day of the week starting next week. Are they allowed to make this change?
So, of course, it's a very significant change to go from working in the office to working at home, or going from home working in the office, or to change from hybrid to being in the office every day. It's a significant change. And why am I saying those words? Because every time you hear the term significant change, the concept of constructive dismissal should come to mind. Your employer does not have a right to make significant changes to terms of employment. So if you're hired to work hybrid, you work sometimes in the office, sometimes at home, now the employer says, we're changing that. Forget about hybrid. Now you're in the office every day. Your employer can't do that. You can potentially treat that as a termination of employment, as a constructive dismissal, and get your full severance. So the choice you have to make is, what is better for me? Am I okay to go in the office every day and that's my new reality? Or am I better off saying, no, I'm not doing this. I'm going to get my full severance, which could be many months' pay, and move on to a different job. No, your employer can't just change your work arrangement unilaterally like this, John.
What if the person's thinking to themselves, well, I might get me out of the house for a little bit more, might be a little more peace and quiet when I'm at work. Maybe I can take this for a bit of a try. Can I do that? Take it for a spin, as we say?
So you can try it for a while. Just tell your employer in writing, in an email or a text message, hey, employer, I'm concerned about this, but I'm going to try it for the next few weeks and see how that works for me. And you do that for a few weeks, then you can still consider it a constructive dismissal if you want. But put that in writing, and it can only be a few weeks that you try it. Any longer than that, you're going to be considered to have accepted it.
And this is because it started as a hybrid. If it was originally in the office, went to hybrid, now they would be able to ask you back at the office at that point.
Well,
right?
I'll give you an example. A lot of people during the pandemic were working in the office, but then they were told, now you have to work at home. So they've been working at home for a while, but the company can say, well, wait a second. Before the pandemic, you were in the office. So now we're going to go back to work the way things were. Now you're going to go back to work in the office. They can do that. What they cannot do is hire you to work at home or hire you to work in the office and then change that on you. Whatever you were hired is the terms of your employment. And just like you can't decide, well, I've decided from now on I'm working from home, well, your employer can't decide that you're going to work in the office. It's a significant change, and that's why we have constructive dismissal laws. And that doesn't apply in this situation. It can apply to demotions. It can apply to pay cuts, to changes in work location. Anytime you have a significant change, think potentially constructive dismissal.
And we are just about out of time. Thank you so much for tuning in. Always have great questions and great answers to go along with. I'll give you some contact information as we wrap up here. The phone number one more time, 1-888-861-4555. Ask at EmploymentLawyer.ca. And for any other information, just go to cp24.com/ask-a-lawyer, and we'll pick it up again next week. Thank you so much for watching, and we'll see you next time right here on Ask a Lawyer.